the perfect match. You all are consumers. You all are using digital content services that collect your data. So what is this relationship between consumer law and data protection law? And with the making of the Digital Content Directive and entering into force of the GDPR, this is a very hot issue. So welcome very much to this panel. I would like to introduce our host, Ursula Pachl, Director Deputy at BEUC, the European Consumer Organization, and co-host together with the Institute for Information Law of this panel. Ursula leads BEUC's work on the digital single market, and Ursula, you will give us a little introduction into the topic today.
Yes, thank you very much for this introduction, Natali, and thank you for having organized this panel. I have to say I really love the topic. It is a very timely topic because having worked I myself in consumer law and policy for nearly 2 decades, if I may say, I can only say that data protection and consumer law have always been 2 very distinct areas of law. And for a consumer lawyer like I have been for many years, these are really separate universe. And in European law, but obviously also in the national law of the member states, I think there have not been a lot of thoughts about how these 2 areas of law interact. But now we're actually in a data economy, and everything is data-driven, and the traditional products, the tangible goods that are around us, they are all connected to the internet. They all have embedded software, or they soon will have embedded software. Services are driven by data. Artificial intelligence kicks in, and automated decision-making processes are all driven by data. Data is the new electricity, as I recently heard. So things are changing very quickly, and I think it's high time that we look at this connection between consumer law and data protection law. And so thank you very much for bringing this up so timely. I think as a European lawyer, so to speak, we can say that we're lucky in both areas. We have very high level of protections, leading protections. If you look at the global situation, both rights, privacy, personal data protection, and consumer protection are part of the European Union's Charter of Fundamental Rights. And with the GDPR, with the General Data Protection Regulation that will be applicable as of May, as you all know, there will be another, we hope, a real milestone that will give back a bit of control, at least to data subjects, and may I say also to consumers. And consumer law is the same, has been, I always say, a success story for the last 40 years of the European Union's integration. The first driver there was harmonization of law, opening of the single market, giving traders the opportunity to sell across borders, but it has always been a spear-headed objective to also protect consumers at a very high level. And with these protections and with these objectives, I think consumers in the European Union have been quite well off. There has been recently a refit exercise of the European Commission. You may know that this is the exercise where the Commission looks at the fitness of European legislation across the board. So the first time ever fitness check of consumer law has led to a result that is quite good. It shows that consumers have really benefited. Businesses have also benefited. And I'm happy to say that the refit clearly demonstrates that the compliance costs for businesses are not very high and relatively well to be borne by the businesses. So a very good result. But at the same time, I have to say, the fitness check has come a little bit too early, in the sense that all these new challenges that we're going to address hopefully today, like the data-driven services, the data-driven products and decision-making processes, they have not been looked at all in terms of how effectively can the consumer law acquis protect consumers in the data economy. So this is a little bit a missed opportunity, if I may say, but we're keen to see that in the review package that will come in April for consumer law, taking the refit exercise into account, we will also be able to address some of these concerns and try to address some problems that can occur. So as said, there needs to be much more underlining of this complementary function that we think that data protection law and consumer law should play, and this is a good opportunity today to look at that. The first, just to mention a subject that we will discuss, the Digital Content Directive. I think it has been the first European legislation where a potential conflict of data protection and consumer protection has come into play and has been put at our radar, if I may say. And Mrs. Gebhardt, who is a reporter on this directive, she can really tell long stories about the discussions that are ongoing. And finally, I think it's really a great opportunity that this is a panel that can also look at the transatlantic dimension of the discussion and hopefully steer a discussion that shows that it's useful for all societies to have this bridging of these two areas of law that we're looking at. And let me maybe just mention, last but not least, that consumer organizations who are also private enforcers, who are litigating, who have been front runners in relation to the big IT companies like Facebook and Google, who have brought them to court, that they have used consumer law to tackle personal data protection policies that have not been compliant with European data legislation. So there we see that bridge. But we also need that the enforcers, the authorities, that they take much more serious, let me say, that the need to bring these two things together. Silos in enforcement, they do not work anymore. We have seen it very clearly now with connected products. Our Norwegian member organization has been a front runner showing how bad connected products can be for consumers. They have identified problems in toys that are related to safety, to cybersecurity, to bad contract terms, intransparency of contract terms, and to data protection. Who has been the authorities who have stepped in, but not sufficiently, but still a starting point, is the Data Protection Authority, nobody else. So let me conclude just this introduction by wishing you a very inspiring talk today, and by thanking in particular Natali, who is going to lead and moderate this discussion from the Amsterdam University, from the Institute of Information Laws, thank you, and Frédéric, who has also been involved in the preparation and sponsor of the panel, and my colleague Justine, who is sitting there in the audience, for having prepared this. So thank you very well. Thank you.
Thank you very much, Ursula, for this good introduction and first overview of the topics, and also the importance and the topicality of the topic. And I'm very, very pleased to introduce you to the panel, so that's my privilege as a moderator. First of all, we have Evelyne Gebhardt. You just came over from the European Parliament, actually, where you've been talking about the Digital Content Directive the entire day, and still you spent your evening with us, so thank you very much. And you are the rapporteur, one of the rapporteurs on the Digital Content Directive, and we're very much looking forward to hear more about that in a moment from you. Then we have Professor Turow, who flew in all the way from Pennsylvania. Joe is a professor at the Annenberg School of Communication. He is one of the pioneers in doing research into user attitudes and user concerns about digital marketing technologies. So true coryphée on this issue, and your research has not only influenced generations of researchers, I think it's difficult to write about the topic without citing you, but also the policy making at the FTC level. So we're also very happy that you are able to tell us something from how this topic is viewed from the other side of the Atlantic. Then we have Justine Massera from UFC Choisir, one of the first consumer organizations who was actually on the ground and very practical, trying to use consumer law to also protect data and data privacy, and explore this link between consumer and data protection law. So it's really great to have also this practical expertise on the panel. And Justine yourself, you have rich experience with legal actions against large platforms like Uber and Facebook and Twitter. So we are very much looking forward to hear your perspective on how does that work in practice, this interaction. And then originally in the program we had Julie Brill from Microsoft, who could unfortunately not make it due to other pressing commitments else on this continent. But we found Frederick, who is probably, I do not have to introduce to you, but he is an internationally recognized data protection expert and a regular at Cpdp. You were with the Institute for Information Law, actually a colleague, and now you are at VUB for your Marie Curie on online price discrimination, and from your PhD on the protection of privacy and behavior targeting on, you thought a lot about the relationship between data protection and consumer law. What I would like to do this evening is first of all use my moderator privileges to ask some questions to the panel and then open the floor to you, because you as data subjects and consumers and experts probably have a lot of questions to this very experienced panel, and I want to give you a lot of opportunity to ask those. But first let me ask Ms. Gebhardt, would you maybe want to introduce us about the state of play of the Digital Content Directive, where we are, what are the key issues, what do you think could this directive add to data protection law, and maybe some of the background of the making of this controversial piece of legislation?
Thank you very much for inviting me, and we had today's opportunity to speak with you as an expert in the European Parliament, because we have huge discussions about is data protection really necessary in the directive or it is not. I say clearly yes, we need, but others say no, and so we have a need for expertise from other sides. And that is what we did today also together. Thank you very much for the opportunity to give you an overview on the state of play of the Digital Contracts Directive. The proposal for the directive came out in December 2015, but the European Parliament only voted on its report last November. The trilogue negotiations between the European Parliament and European Council, which will produce the final text, started in late November and will most probably be concluded by May or June this year. Why did it take the European Parliament almost 2 years to come up with a position on this legislative proposal? At the start, internal dynamics were to blame. Two committees, the Consumer Protection and the Legal Affairs Committee, fought against each other in order to become the only leading committee on this legislative file. In the end, both won or were defeated at the same time. Both committees became leading committees, and two members of the European Parliament, me and Mr. Voss from the European People's Party, became rapporteurs. I am a social democrat who has fought to progressive consumer protection laws for many decades, and Mr. Voss is a conservative who represents rather the interests of the business side. And I have to say, we had to propose a common text. And I have to say, it was really not easy to do so, because the point of views were really very, very, very different. One could think that this is the ideal starting point for a true and just compromise. But the lobbying campaign behind the scenes against this legislation has been quite intense and vicious, I have to say. Let me remind you that what this legislation is all about. The directive establishes that there is a contractual relationship when consumers pay with their personal data for digital content or digital services. This subsequently means, for instance, that Facebook has to observe all applicable consumer protection law once the user has accepted its terms and conditions. Furthermore, this directive will regulate all conceivable digital content products and digital services. This means cloud computing, social media platforms, and online computer games, but also online communication services. It was crucial for me that a number independent interpersonal communication services such as WhatsApp or Snapchat or Skype fall within the scope of the directive, what was not foreseen in the text of the European Commission. By including these services, consumers will have specific conformity rights inexistent today. If consumers come across problems with an online communication service, they should be able to rely on remedies provided by consumer law. This will also mean that providers of online communication services will have to stop using consumers' data provided as a counter-performance when consumers terminate the contract. Let me be very frank. I am, and I have always been, against the commodification of personal data. In the beginning of this legislative process, I have been quite skeptical whether it should be legally acceptable that consumers pay with their data. The truth of the matter is, however, more and more businesses provide their services against data, which are generally used for advertising purposes and create a tremendous source of revenue. We, as EU legislators, would simply fail to do our job if the law is not changed to reflect this new reality. In the end of this legislative process, all consumers in the European Union in 28 or 27 member states will enjoy consumer rights in these, until recently, still uncommon contractual scenarios. I would also like to point out which important issue has not been solved in our negotiations so far. It is the actual scope of this directive. More precisely, the question, what do we do with smart goods, with the Internet of Things? According to the original Commission text, and more importantly, according to the general approach of the member states, digital content embedded in tangible goods is to be excluded from its scope. This solution would lead to bizarre results. Pre-installed application on smartphones or smart cars would not fall under the directive, while the respective updates would be included. I have always been of the opinion that we do have to include smart goods into this directive, because most of the provisions which are necessary to fill the regulatory gap in this field are equally or even more important when digital content is embedded in goods. This is why the European Parliament's text includes smart goods. As co-rapporteur, I am fighting to protect the European Parliament's approach for a sensible inclusion of the Internet of Things in the final text. We cannot possibly overestimate the importance of this field. In the near future, smart goods will dominate the market. Consumers who buy these products, which are, by the way, very costly today, shall benefit from rights introduced through this directive, such as updates, interoperability, a secure digital environment, and the right to recover their data upon termination. The outcome of this fight, however, is less than certain. So I hope in the next time we will fulfill what is not done today, but I have to say I cannot accept any text at the end which don't really tend to give the best possibility for consumers in this area, because it is really very important, and data protection is for me one of the most important things today to ensure for people. Thank you very much.
Thank you so much for this very useful explanation of what is going on actually in Europe and what is at stake also. Justine, you have a lot of experience actually with breaking down the silos that Ursula was mentioning, and actually testing to what extent consumer law and data protection law can usefully complement each other, as Ms. Gebhardt has also already suggested. Could you maybe tell us something from your experience with practice, and where the gaps and issues? And
so yes, I'm working as a legal counsel at Choisir, the French consumer organization, and we've used consumer law on several occasions to scrutinize the fairness on the terms and conditions of company that collects personal data. Since 2014, we are tackling unfair terms of social networks, Facebook, Twitter, and Google+, before the High Court of Paris, because we consider that data protection law needs to be regarded as a consumer protection provision. In our conclusions, we consider that most of the breach of data protection law, meaning that lack of information, invalid consent, sharing data with unidentified third parties, or transfer to third countries, create a significant imbalance between the rights and obligations of the parties to the detriment of the consumer. Why that? Because consumers must give their personal data to be able to use the service, while the use of those data is contrary to the data protection provisions. By the way, in France, the Abusive Clause Committee clearly makes the link between the infringement of data protection and the abusive nature of a clause, because the infringement creates for the committee a significant imbalance. So I can give you some examples that we saw in social networks terms. For example, the unclarity of the terms. So the general default of clarity and understanding of the terms of most social networks cannot satisfy both the requirements of the consumer code, because the consumer code says that the terms must be presented and worded in a clear and understandable way, which is not the case here, and data protection law, which provide that persons must be informed not only of the existence of the collection of the data, but also of its main features. For example, the terms of the social networks do not indicate the personal nature of certain data exploited by the social network. So, by not enabling the user to realize what constitutes a private data and the existence and type of processing of such data, while assuming his or her consent to the collection and use of these data, we, as Choisir, we consider that the social network collects and processes personal data in an unfair and illegal way, in violation of the provision of the data protection law. And moreover, the lack of understanding of the terms by the consumer, who is the weak party and novice at law, creates an imbalance for the benefit of the professional, making these terms abusive under consumer code. So this is an example. I'll give you just another one about the systematic exclusion of any liability of those social networks. So these kind of clauses are illegal under consumer code, data protection law, and abusive under consumer code. So first, the social network commits itself to a simple best effort responsibility for the security of the platform, but by its statute as a professional providing online services, the social network is bound by a performance obligation under the consumer code. So this clause is illegal. Moreover, the social network as a data processor has to safeguard and prevent the distortion, damage, and accessibility by a third party of the data he processes. So this clause under the data protection provision is illegal. And at the end, the Abusive Clause Committee deemed this clause, this kind of clause, as abusive because, again, they create a significant imbalance to the detriment of the consumer. Because, the professional doesn't have any liability while the consumer has to give all his data and cannot do anything about that. That's why I had to say.
Thank you so much, Justine. Joe, if you listen to this, I mean, in the US, you have a very long tradition actually of using consumer law to protect privacy. You hear that in Europe, we actually arguing very strongly for that. What do you think? What advice would you have for us?
Well, I would say be careful what you wish for. I'd say be careful what you wish for. To some extent, but countries are different, cultures are different. When you talk about paying with data, for example, the way that it's often phrased, as I hear it in the US, is the notion of trade-offs, that basically a company will trade data for the benefits that you get. Now, we've done some research in national surveys, and if you ask people about the philosophy of trade-offs, most Americans are against it. If you give them a scenario or a number of scenarios where supermarkets give discounts for giving data, they'll accept the discounts and they'll give their data in these scenarios. But if you probe why that is, it has nothing, I would argue, to do with trade-offs. It has to do with resignation. The notion that people feel that there's nothing they can do about it anyway, and that's why they give away a lot of their data. They try to figure out what's good for them. But in general, the sense is they're resigned. And we asked people about that. We gave them two statements among a lot of other statements. One was, I'd love to be able to control the data companies have about me online. And the other was, I've come to believe that I have little control over the information that companies have about me. And these were separated by other statements. And we found, this was 2 years ago, that 58% of Americans feel that, okay? The other statement they gave, which I think is really even more interesting in some sense, true or false, when the data that companies have, information that companies have about me can't hurt me. And a large percentage of Americans said that was false, that data in fact can hurt them. And if you put all three statements together, resignation and this sense, 48% of Americans were resigned and felt that the data that companies have about them can hurt them, okay? Now, if you look at the ways in which the data activities and regulation under the consumer banner have taken place, I think that it's a good case for how vested interests can capture various parts of society. Also, in terms of revolving doors, a lot of people who work for agencies that are involved in this, they know where they're going to end up working. You don't get a whole lot of money working for the federal government compared to other of these other companies, and there is this door that people use to get in, either intentionally from the beginning or not. If you look at the issues there are, of course, deceptive aspects that sometimes the regulatory agencies like the Federal Trade Commission have gone after, and there are some sectoral issues that people have around health and special interests, special parties. But in general, I think the feeling that a lot of advocates have in this arena is that, and particularly under certain regimes, but even under more liberal regimes, companies have a say in what goes on. And they pretty well can do what they want. If you look, for example, at the Amazon Echo and the Google Home, you guys are familiar with this, the assistants, those have sold recently, as of this past Christmas, are the fastest selling electronic products compared to, for example, they've been selling on the upswing faster than cell phones when cell phones first came out. People are scarfing this stuff up. If you read Amazon's privacy policy, it has the right to take data about everything you say on that platform and capture it. I don't know what they're going to do in the EU, but in the United States, this is going on all the time. And I had my students go through the skills privacy policies of companies that relate to the Google Home and the Amazon Echo, and they don't even mention those two devices, but many of them give away data like crazy to third parties, buy data about you, okay? So we're talking about a world in which this data are in fact the coins of exchange, and people have very little understanding of what that means. And I just want to add one more terribly important wrinkle in this, and that's artificial intelligence, okay? That is the really driving force now in so many areas of marketing. And there's very little to prevent the algorithms that are created through artificial intelligence to be used in a US context in pretty well any way that marketers want. It's also an international issue. If you know about the scoring that's being done, for example, in China today, social scoring, and the issues around, recently at the CES, the Consumer Electronics Show, the head of Baidu, which is the Chinese Google, was extolling how the Chinese government is pushing artificial intelligence. Well, the boundaries between commerce and government are really pretty blurry increasingly. And I think we have to think about what are the implications for research and development in a marketing arena, okay, under the banner of marketing, and how that ends up flowing to government. And consumer protection law, at least in the United States, hasn't really done anything to stop this sort of thing.
Okay, clear words, thanks so much. You get an opportunity in a moment. But first, actually the little control that you were talking about is part of the reason why we talk about consumer law, because one of the criticisms of the GDPR is that it's still very much based on consent and people don't read the privacy policies, and consumer law could help. Frederick, I know that you've been thinking a lot. Actually, we've been discussing a lot about that when we wrote that article. So I would be really curious to see what is your take. Can data protection, consumer law actually add something, at least in Europe? Or do we risk to actually sell our data away if we go that route?
Is this on? Very good question, Natali, because some part of the background of this panel is that with Justine, Natali, and me, we wrote a paper on the intersection between consumer law and data protection law. We've been thinking a lot about it, but also there's hardly ever any research projects that we had so many discussions, because like many people, especially on conferences like this, I kept on screaming, come on, data protection and privacy, these are human rights. We don't want to whitewash selling with personal data. We should keep this separate, because human rights is not it's on a more important, higher level than like simple consumer law. That's about washing machines that break down, etc. So that was my starting point, but I got more enthusiastic about the interplay. Apart from that, because I could imagine that some people in the audience are going to make similar arguments, and I do have sympathy for the view, like you shouldn't mix human rights with other reasoning. But apart from what we would like, law is just messy, and we can't steer, lawmakers cannot steer, and scholars cannot steer what judges and activists do. So if activists go to court and use consumer law in against, for instance, badly secured smart toys that listen to everything in your house, and a judge applies the law, then, well, we can't help that. Law is messy. So whatever we like of the interplay is going to happen anyways. And I'm actually now in the camp that I do like the interplay. But if any of you don't like it, I have bad news. It's going to happen anyways. So without you having any influence on it. I'll keep it as that because I'm interested in the comments from the floor.
Yeah, I would say use your influence now. It's the time. And herewith, I actually would like to open the floor for the discussion, because probably you have burning questions and would like to talk. I would like to ask you more other questions as well, but I actually give you the opportunity. I would suggest that I take 3 questions and then back to the floor, so that we go by 3. Who would like first? Yes, I see. Do we have a microphone?
Yeah, there's coming one.
The mic is coming your way.
Thank you, Katarzyna Szymilewicz, EDRI and Panoptykon. I would like to invite comments from the panel on the question of transactions where consumer agrees, voluntarily agrees for a service in return for data. So I'm not talking about, in my opinion, clearly illegal on the grounds of GDPR situation when we are forced to do so, But how about a situation which is framed in a voluntary terms? Let's imagine I have an agreement with Facebook or any other company, and then I'm offered a bonus, or maybe a bank or an insurer. So in return for a bonus or additional service, I'm asked to provide more data. How you see those transactions on the grounds of both GDPR and consumer law? Speaking openly, do we have, in your opinion, any legal tools to attack those transactions, or we simply have to live with them? Thank you.
Thank you. There's a second question up here and close to the island. Two, actually. Yeah.
Hello, Alunga Rojas, PhD student. Okay, concerning the French speaker, sorry, on the consumer protection law, when I open the website, I usually see something like, by using this site, you consent to the placement of cookies. Read our privacy statement to learn more. And they say agree and dismiss, not agree or dismiss. Okay, now, is that normal? Is that legal? I mean, maybe post 25th May 2018, should such websites be taken out of the internet? I mean, I would like to hear your opinion on that.
Thanks. Michael Donahue with the OECD. And let me just first agree with Frederick that these issues are intertangled in a way that we're not going to separate them. And I give you one point of evidence, which is we just revised our consumer protection guidelines for e-commerce. And indeed, consumer data was one of the fundamental themes. We've expanded the scope to cover non-monetary transactions, to say that consumer protections apply to those as well. We say don't commit deception when it comes to privacy policies, and there's even a little privacy section. It's right there, interwoven. What we don't have in there is data portability, and that's my question, and I'm going to put it provocatively. Hasn't the data protection community shamelessly stolen data portability from the consumer angle, which is really where it properly belongs as a competition-inducing mechanism?
Is it related? Otherwise,
Well,
you would be in the next round.
I think it's related to,
Okay.
to the theme, and I think it's in response to Michael. And reflecting what Joe just said, what do you think the responsibility is of the EU and the advocates in the EU, given that largely in the United States and elsewhere, US-led companies, especially Google and Facebook, have created a whole new standard for data collection and for consumer interactions that's largely unregulated, that doesn't protect the consumer or citizen. What should be the EU response to respond to this largely unregulated digital consumer environment?
Thank you. I'm looking at the panel. Who would like to give answer first?
So I will try to give one answer. I think it is really very, very important that we introduce the GDPR within the consumer acquis. Because if we don't so, we will have many problems where data are used, but we don't. If there is a problem at the end with the conformity, it will not be a possibility for the consumer to go away of the contract. And that is one of the big differences we have in the discussions within the European Parliament. The one says there is no necessity to do so. We have the GDPR, and it is here, and it is the best we have. And I am saying, yes, it is okay. GDPR is a good piece of work, but what is when we don't have a conformity? And you had a beautiful example this afternoon with that. How do you say? Comment vous dites poupée en anglais? A dog, doll. Okay. This doll, not dog. Yes, a doll. I'm sorry. It is easier for me to speak French or German, but English, okay. With that doll, which is now to buy, which has a dialogue with the children. And in that dialogue with the children, many data, which are sometimes very sensitive, are given, and nobody knows who has at the end this data. And for that, there is no regulation within the GDPR, because it is not the reason why we have the GDPR. So we have to include it in the consumer law to ensure that the people who have that doll can resign from that buying and become back the data they gave or the child gave at the end. If you don't ensure that, we will have a big problem. And we don't know which persons will have the informations given by that little girl. Yes, we can have an imagination what can be possible. And we don't want to have that. And that is the reason why I think it is really very important that we introduce it in the consumer key.
Actually, you have to destroy it before the eyes of your kid.
I'll give some reactions. Is it on?
Yeah.
Somebody asked Adri, I think, about take it or leave it choices, where a service or an app or whatever says, for instance, you can only use this when you agree to us collecting all this personal data. An infamous example is such so-called tracking walls on websites. You arrive at a website and it says, do you agree to us and 30 ad networks that we partnered with, and because of real-time bidding, another 10 that we can't predict which. Do you predict, no, do you allow that they all drop flash cookies and normal cookies and HTML5 tags, etc., etc.? If not, you cannot enter the website. What to do about such take it or leave it choices? This is an extremely complicated question, which is super political as well. Because the more libertarian leaning you are, the more sympathy you have probably for the argument, well, it's your own choice and you can go to another website. And the more left-leaning paternalist you are more tempted to say, no, the lawmaker has to do something. The GDPR took a nuanced and somewhat vague approach and basically says, such take it or leave it choices are extremely suspicious and consent has to be really freely given. But the GDPR doesn't say such take it or leave it choices are always prohibited, which is probably the right way to regulate that question for an instrument like the GDPR with an enormous scope of application. But how should it be regulated in the future? The e-privacy regulation, now in the current version, the European Parliament version, bluntly says, and I have sympathy for the choice, such take it or leave it choices are prohibited. It's a political choice. It doesn't logically follow from current law, but I think it's a pretty good choice. How consumer law can help, I'll leave that to others in the panel. Fascinating to hear that there's new consumer protection guidelines of the OECD. I'm going to check that out. And didn't data protection lawmakers choose data portability from consumer thinking? Yeah, they probably did. Yeah. And then what is the EU responsibility? Well, the EU apparently takes responsibility for protecting personal data and for protecting consumer law. Now it's actually pretty obvious that the EU does. It wasn't in the early 90s, not for personal data rules, but they took that role quite successfully. Yeah, I'll leave it at that.
Yeah, maybe just to use the example that Mrs. Gebhardt brought about Kyla and how data protection rules and consumer law can work together or not. We have been fascinated by this example because if you look at it from a result-oriented perspective, you want to make sure that these products are not on the market, number one, because they have serious problems. Data protection is one, data security is another one. Infringements of consumer law in regard to unfair contract terms, it's there as well in these products, but it's not even that important. But if you look what happens, It's basically nothing. These products are still on the market, despite our Norwegian colleagues have disclosed all these problems more than a year ago. In Germany, there was a very specific law, a national law that has been applied, and that obliges consumers who have the toy at home to destroy it. Nobody talks about giving the data back. Nobody talks about giving the money back to the consumer, because this is really cheating. You bought something, it has even a label that it is internet safe, whatever that means. So really misleading. But what are the remedies of consumers of these breaches, for example, of data protection? You could also say in the future GDPR, but also in the current law, we have also obligations to secure the processing of data, which definitely have been infringed by these products. So the question is, what can we achieve with the GDPR? For example, it would be the maximum sanction of the data protection authorities that are now on their way to intervene in France. The CNIL has given notice to the producers of Kyla. Maximum sanction, stop the processing of these data. What happens for the consumer? I mean, I still would have this doll at home, and I still paid a lot of money, because as Mrs. Gebhardt says, products are quite expensive, for something which really does damage my child probably and my home, and it's really something where I don't have a right. I mean, you could probably interpret it certain provisions to get to this conformity deficiency, but it's not very clear. So this has to be made clear so that consumers have remedies at hand.
And if I understand the German solution, why they had to be destroyed, it was actually not because of consumer law, and it was not of data protection, but because it was because of the espionage laws. It's a spy tool. That's why it had to.
It has to be destroyed. It has to be off the market. We were traveling to Germany. We were traveling to Germany for a conference and wanted to give a presentation on Kyla, and then we said, well, we get into trouble at the customs if they see we have Kyla with us, because it's not forbidden to have it at all. So better we leave it at home. So we left the doll at home.
So, Joe, if data protection law is not working, consumer law not working, maybe espionage laws are working.
That would be interesting. Although in the U.S., who knows? But I did want to say one thing about harms, which you brought up is a really important issue in the United States, at least from my perspective. The definition of harms by the Federal Trade Commission is rather narrow. Your presumption of harms would not make the case, okay? You have to show health, you have to show employment. Those literal quantifiable harms are the definition of harms. Talk about sociology of harms, the history, the long arc of privacy, non-protection. Any of those things are really not harms. And so it creates some very big problems when you try to argue that a harm has taken place and you can't literally quantify it.
Thank you, audience. Oh, I see Augustine. Want to steal mine?
Just like to add something on the issue of harm. And I think that's a very important and valid point. It's very difficult sometimes, even under European legal traditions, to prove the existence of such harm in this type of situation. And that is the beauty of consumer law. Because when you talk about conformity, you don't need to prove any harm. You just prove that the product was not in conformity of what you have been promised, and then you can get your money back. And that is the real added value of having this interplay with consumer law. Because at the end of the day, what we want is that these products are put out of the market, and that's a matter of the surveillance, the enforcement authorities. But there also people get compensated, they get their money back. If there is a harm, there is a different story, and then we have to see in the national laws how this is going to be compensated. But at least EU consumer law can provide an effective remedy to say you get your money back if this product is not conforming with the criteria that actually the European Parliament, now the legislator, is working on. Thank you.
Well, that would be under deception in American law too, but you'd have to, I'm talking in the more broad sense of a website or an app creating harm in a larger understanding of what that means. So not, I paid for something that said it was internet safe, it's not internet safe, okay? that you could say is a lie, whatever internet safe means. But if we just had a product that was talking and listening to you, and the privacy policy says all of that, and somehow it came with a privacy policy, I think you'd get away with it. And it'd be an interesting problem. I don't know how you can call it a harm. You'd have to prove to the court that some harm was done.
It's
Nico,
a little bit in addition to what was said before.
maybe introduce yourself.
Yeah, Nico van Eyck,
Everybody knows
Institute for
straight away
Information Law. There is also, for example, unfair business practices, and there's also a difference between the rules on unfair business practices in Europe and the US. In Europe, we have, for example, a blacklist, and there also you don't have to prove whether there is harms. So if it's a practice that's on the blacklist, it's forbidden, and remedies are available. And coming to remedies, I see some members of the panel who are in total despair and claim that the law is not working. But I think what they are actually saying is enforcement is not working. And I have heard this too often, that the law is not working. And every time I challenge people and I say, I can give you at least 3 rules that you could apply in this specific case, but it does demand a certain level of guts, and without guts there is no glory. And I think that what we often forget in Brussels when we make regulation is it's not just about the regulation, it's also about the follow-up. What are courts going to do with it? What are regulators going to do with it? And we have only a very, very young practice of regulators being involved in these kind of issues. The FTC was created more than 100 years ago. The FCC is also, I think, almost 100 years old, or close, 35, or 1935, I think they were created, 34.
Radio Commission was 27.
Yeah, 27. But, and most of the regulators we have are extremely young, have a very short record of being active, and particularly when it comes to enforcement. This will also be one of the big issues for the DPAs, because DPAs, although they might have been in existence for, let's say, 2 decades or maybe 3 decades, they have not yet developed a very rich practice of applying rules and enforcing rules. I think the CNIL is slightly an exception to the rule, but a lot of European DPAs are famous for serving excellent tea, but not for being effective enforcers. So I think there is still a lot to explore within the rules that we have, and we should not be afraid of that, because when we say we need new rules, it also means that we say the existing rules don't work, and new rules take 4 to 6 years. So you're actually legitimizing by saying that the laws don't work, that we don't do anything for 6 years, or at least you have the risk that that's going to happen.
So another question there. Yes, you. Was that here in the 3rd row? Would you give the mic to the? Was that related?
Thank you. Romain Robert from the EDPS. You know that EDPS issued an opinion, I'm sure you know, about this directive, this proposal for a directive, and you know the position of the EDPS, which was to be well understood, not that you cannot consider that data are used at a value, but just, and I would join you on this point, not to make it too complicated for the judges and for the DPAs, while we already have a GDPR really fresh and not even applicable yet, with rules that even the DPAs, as you just mentioned, still have to discover, with this rule of consent, which is, let's say, not really clear, when consent is really presumed or deemed, or it depends on the language of the GDPR actually, to be not valid when you use it to access a service, blah, 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 we know this. And so the EDPS made it very clear that we should try to avoid any complication of the rules. But I think that the bottom line of this discussion is, of course, this consent problem that was not really solved in the GDPR, because I think this Article 7.4 is the result of a political compromise and a lot of lobby, of course, on this provision. And then leave, as you mentioned, a margin of maneuver to, in the future, to know where to set the cursor. That was set by the GDPR in this way, And what the EDPS wanted to say is that please don't, with this directive, set the cursor back this way. So that's why we try to say, and then I will have to play the rules of the game, which is raising a question, I guess. Do you have an idea of where this cursor should be set? Do you want to change it? Do you want the regulators to think about it later? Do you already want to set this cursor in this new text or in another text? Or do you want to leave it up to the consumer protection authorities to set this cursor of where this consent is supposed to be valid and then where this doll is legal or not? That's a provocative question, of course, but otherwise it's not interesting at the time of the day, I guess. But I think it's the bottom line question. Where do you set this cursor of when do you accept that you exchange your data for a service, and when don't you accept it? Or do you accept it all the time?
I will try to answer. I don't want to change the cursor of the GDPR. We have the GDPR and it is that it is. It is a good thing. Sometimes I think it could be better, but as you said, it is a compromise. But in the end, it is not a bad compromise. What we are speaking in the digital content about is the use on conformity. And that is somewhat else. We are not changing the GDPR. We are not making an interpretation of the GDPR. We are saying what is happening for the consumer. If there is a problem, what are the remedies? How can we tackle these problems? And that is something absolutely another thing. That are things which are not ruled in the GDPR, and it is not the rule of the GDPR to do so. And that is the reason why I think the discussion sometimes we have making a mismatch between both. It's a wrong one. It is one to say we don't want to have remedies. It is saying we don't want to have rules for our business models. But it is something else. I hope it was understandable what I said.
I will briefly react to the question by the EDPS. Where should the cursor be set for take it or leave it choices? I have a lot of sympathy for the European Parliament position in the e-privacy proposal. Like such take it or leave it choices are banned, prohibited. Immediately, consent is not free. Yeah, I like that version. In the end, that may have to be, I mean, the e-privacy regulation still has a somewhat narrow scope, so there's many situations in real life that are outside the scope of that rules, but I like that approach. A bit of pretty paternalistic, but sometimes I think there's very good reason for paternalism.
Maybe just to add one thought, but this is not really a mature thought, but just to mention that I think the quality of consent, if you look at consumer contract law and what consent do you give to accept the terms and conditions of a contract, it's not as high as the consent that you have to give according to data protection law. So there is this difference, and the court would interpret it differently in relation to what have you been asked to do and what you have given as an answer, an explicit answer, or did you just cross on a box? So there is in law, in interpretation of law, there is a different quality that is also complicated when it comes to this type of contracts on digital content that we discuss. But I just think that this one question that you raised about the harm is really a crucial one that we didn't discuss enough in Europe, which is really how do you measure the damage that comes from infringement of data protection law. And this is why and I would like to hear Frederick's opinion on this, because as long as you cannot, for example, we don't have collective redress here in Europe, unfortunately, but how do you act if you had collective redress against data protection infringements, but you cannot measure the damage? that you have because of that. And I guess in the future it will be easier to measure the damage because the data economy will make it probably much more relevant that your data have been used to exclude you from certain things, to ask you to pay higher prices and to personalize offers that you get, but you don't get other offers, and these type of questions.
Perhaps in the future you would need a system where you say any breach of rule X from data protection law is worth a penalty of 50 euros. So it wouldn't make it interesting for the individual consumer, but with set damages, that could be rather low, but if you combine that with a kind of class action system, then it should become really scary. Oh, but Mr. Turow?
What do you think?
Yeah, about collective redress and data protection, the GDPR gives them the right to member states to implement collective claims to obtain injunction of the breach of the personal data infringement, but does not provide a compensation mechanism. And I was talking with a French deputy last week because there's the draft French data protection law, which is now being drafted. And they are thinking about do we keep it like just class action for injunction, or do we make it to compensation as well, as the class action is implemented in consumer law. And for us, it's really important that the compensation is implemented, and the French government is quite in thinking the same way. So we are still waiting, but we have good hopes. And we think as well that compensation of non-material damages should be taken into account. And as you were saying, that we cannot measure the damage made by a data breach, I do not really agree with you, because we kind of pay with our data. So data today has kind of a price. So if you reverse the mechanism, you could be able to find the price of a data. I can't find my word anyway. And last word about the. We also think that the recognition of the calculation of the damage by a lump sum would be a good idea, as you were saying, that, for example, one data breach would be worth 500 euros, or a data breach of one photo of that many data would be worth that amount of money. This would be also a way to be able to calculate the damage in collective redress of data protection.
Thank you. I just want to say that a trend in the U.S. consumer law that I've been noticing, even in my personal life, is more and more contracts that prohibit class action suits. And they actually will say that if something goes wrong, the only way you can get redress is, in fact, one that I had recently said you have to go to a small claims court only, and it has to be with arbitration. So the movement now and in contracts this was for a home warranty company that I recently got, and I compared. I had a digital version of the one I had 3 years ago that didn't say that. And in the last couple of years, they've added that. Now, there's been a complexity in how courts deal with these things, but the movement has been toward not allowing class action suits in these consumer situations just because they don't want to be held to those notions of harm.
Thank you. I see that you already triggered more questions in the audience, and I saw more questions, but we're running out of time. I think the good news is that there will be drinks. So maybe I would like to invite you to continue this discussion with something to drink, because it's really hot here. I would like to invite you to give a big applause for our panel.